Well, hello, guys and girls. Hope you guys are doing well today. It is the first day, January 2023, that is. And tonight I'm going to be sharing from the Redemption Manual 4.5. And my YouTube channel is Discerning What is True. And welcome you to the broadcast. This is live tonight. So I'm going to be reading this important manual that is to redeem yourself and get yourself out of the system. Others have tried it and have actually done it. Um, Gene Keating has done it. A couple other people have done it and have done well with it. So we're going to start reading this particular chapter here. The chapter is Methodological License to Practice Law. Every so-called state in the Union has laws on their books forbidding the unauthorized practice of their law. This fact alone might lead one to conclude that being a licensed member of the legal profession is not only required, but that one not so dutifully appointed had better not even think about offering legal writings or advice without having a license to practice law. To test this assumption, we go to California, the so-called Union's most populous so-called state, our test subject, to see how they do it, California style, that is. So to begin this journey of discovery, you can go online to the Secretary of State of California, for California, that is, website. All bona fide corporations, public and private, must be registered with the Secretary of State. Do a search for California Bar Association and notice that several strange anonymies with the posted information. For one, while the incorporation date of record is listed as 1907, this date differs from the date on the seal of the letterhead for the California Bar that lists that it was incorporated in 1927. Now, notice that the status of a California Bar is inactive. Also, notice that there is no registered agent listed for services or process, nor is there a listing for the corporate address. Go to the Secretary of State website for the so-called states neighboring California, and you will discover the same anonymies, listed but inactive, without contact information. Wonder what's going on here, guys. Now call the California Corporate Commission to discover if they can explain the so-called anonymies, and they will advise you that the State Bar of California was formed by statute, that is, Legislation Act, and therefore not formed in accordance with the California Corporation Code. Next, call the executive director at the headquarters for the California Bar Association in San Francisco and ask the following three questions. Why is the California Bar Association an inactive corporation? Two, what type of organization, that is legal's classification, is the California State Bar Association? Three, why does the incorporation date on the letterhead seal different from the date of the incorporation listed with the California Corporation Commission? While the executive director will not be able to clear up the mystery to any of the questions listed above, you'll be assured that the State Bar of California is a constitutional agency with the judicial branch of state government. It serves administration function for the California Supreme Court in matters relating to the regulations of legal professions. However, the California State Constitution and the California Business and Professional Code does not agree with this claim. These two authorities, that is, describe the State Bar of California as a public corporation, not a constitutional agency. Let's continue. To complicate matters further still, the California Secretary of State refuses to issue a certificate of non-filing, a $5 fee, a standard form for any unregistered, non-filing public corporation. By claiming that the State Bar Association was created by legislative act, the Secretary of State can take the position that it lacks authority to issue the certificate, even though the State Bar Association actively tours itself to be a public corporation. In so doing, the California Bar has effectively exempted itself from registration and shielded its books from public scrutiny. The following obscure cite from 7 Cors Juris Sectorum, number 9, reveals the deceit being perpetrated here. And this is a quote here. In view of the decision that the creation of public corporations by special acts is prohibited by state constitution. You hear that? State Bar Act creating state bar corporations as public corporations has no validity, and designation of state bar as public corporations has no legal efficacy. This is based upon Bridgegroom versus State Bar 550, P.2D 1089, 27 ARIZ app.47. To further interpret what this means, the State Bar of California enjoys the best of both worlds. Apparently, an agency of government enjoying the power and protection of the state, including exemptions from taxation. While it is, in fact, a private institution without legal basis. Continue. Whereas the notion of a license to practice law is scarcely mentioned in state and federal codes, the requirement relating to every other kind of license in existence is spelled out in mind-numbing detail, like vehicle code, internal revenue service code, etc. But the sacred license to practice law, however, remains undefined. Answers to questions regarding where it comes from, how it is conferred, where one goes to see what it looks like, its tender, its costs remain elusively like the wind. These and other intensely pertinent questions remain unanswered by the codes that imply its existence. So pull up a chair and take a front row seat as we examine what the word manipulating esquires have done to convince us that such a thing really exists. As always, the subterfuge is in the definition of the words and what is conveniently omitted. It is up to you to guess which words are suspect, which assumptions are implied to lead you off track, what remains unspecified, where to go to find the appropriate definitions. In code series, that is 6000 of the California Business and Professional Code, that is CL, Cal, B, and P, is known as the State Bar Act, Section 6002. It is the solitary code section in all of California Code, evidencing the supposed issue of a license to practice law. I will list out the relevant sections in California Business and Professions Code relating to the issues of licenses and also Section 9 of their California State Constitution. Look these over to see if you can tell where the clues are and note what questions to ask. California B&P Code Section 6001. The State Bar of California is a public corporation. California State Constitution Section 9. The State Bar of California is a public corporation. California B&P Code Section 6002, members. The members of the State Bar are all persons admitted and licensed to practice law in the state. California Business and Professionals Code Section 6125, necessities of active membership in State Bar. No person shall practice law in California unless the person is an active member of the State Bar. California B&P Code Section 6060, to be certified to the Supreme Court for admission and a license to practice law, a person who has not been admitted to practice law in a sister state. California B&P Code Section 6060.5, neither the board nor any committee authorized by it shall require that application for admission to practice law in California pass different final bar examinations depending upon the manner or school in which they acquired their legal education. Okay, California Business and Professions Code Section 6064. Upon certification by the examining committee that the applicant has fulfilled the requirement for admission to practice law, the Supreme Court may admit such applicants as their attorney at law in all the courts of the state and may direct an order to be entered upon its records to that effect. A certificate of admissions thereupon shall be given to the applicant by the clerk of court. California Business and Professions Code 6064.1, no person who advocates the overthrow of the government of the United States or of this state by force, violence, or other unconstitutional means shall be certified to the Supreme Court for admission and license to practice law. California Business and Professional Code Section 6067. Every person on his admission shall take an oath to support the Constitution of the United States and the Constitution of the State of California, and faithfully to discharge their duties of an attorney at law to the best of his knowledge and ability. A certificate of the oath shall be endorsed upon his license. Continues, section jurisdiction. So section 6002 and 6125 appear straightforward until the jurisdiction are compared. Jurisdiction, that is California, means the de jure social compact known as California Republic, as described in 1849 California Constitution. The jurisdiction in the state per California Revenue and Taxation Code means the de facto military social contract defined as a federal territory, that is by the Buck Act under military control of the United States located in the District of Columbia. So you see that basically one group is accepting it in what they call de jure, which is the true social compact, and the false one is the de facto military social contract. Continue. Persons. Since the so-called bankruptcy in 1933 in this state signifies the military federal social contract known as the state of California with its subjects, that is, citizens of the United States, artificial persons existing under statute in an artificial realm. In the de jure California, the word person means the flesh and blood, man or woman. Thus, Section 6002 says that only artificial persons, that is, legal fictions, may be admitted and licensed. Real persons need not apply. Since the jure social compact known as California no longer truly exists due to the fact that the compact went out of legal existence in 1933, as a pledge to the military social government construct bankruptcy, Section 6125 is nonsensical. It makes about as much sense as stating no person shall drive an 18-wheeler on interstate highways in California unless that person is a member of the Teamster Union. What is the state bar? Another fatal flaw to look at is in both Section 6002 and Section 6125, according to Corpus Juris Sectorum 9, listed above, and the Secretary of State, is that the state bar itself has no legal existence. In contradiction to Section 9 of the California State Constitution and the California State Bar Act, Section 6001 states that the state bar is a public corporation. The state bar is a public corporation that is not, and the State Bar Act creating the state bar has no legal efficiency. Wow, what a confusing mess. California Business and Professional Section 6002 informs us that members of the state bar are admitted and licensed to practice law. Admitted in what? And who does the licensing? Section 6002 is framed to satisfy the reader's perfunctory inquisitiveness while remaining firmly ambiguously. Also, the reader of Section 6002 may get the impression that bar members are the only ones that may be admitted and licensed to practice law in the state. However, because of the way the Section 6002 is worded, non-members of the state bar are not excluded from being admitted and licensed to practice law in the state. In addition, bar membership is a result of being admitted and licensed to practice law, whereupon the admitted party is then granted membership in the state bar by a bar code, not the other way around. Generally, membership in the Bar Association is optional with the individual attorney. But where a unified or integrated state bar organization is established, membership and payments of dues may be required as conditions of practicing law in the state. 7 Corpus Juris Sectorum 8. In Re Gibson 4 P capital P dot 2D 643.35 N, that is a capital N and M dot 550. Though the controlled and licensed media and courts would have us believe otherwise, non-state bar members are not excluded from being licensed to practice law in the state. Again, the California Business and Professions 6060, 6060.5 reveals that the license to practice law follows is one and the same: admission to practice law, not membership in the Bar Association. Section 6060 says that one may be certified to the so-called Supreme Court, admitted license to practice law, even if they haven't been admitted to practice law, that is, no bar code in another state. The article in Los Angeles Times entitled, entitled Clinton Resigns from the High Court Bar, underscores this point. Former President Chris Clinton hereby respectfully requests to resign from the bar of this court. His lawyer, David E. Kendall, Kendall, sent in a 2-page letter to the High Court clerk. Clinton's resignation from the Supreme Court bar will have little practical impact. Clinton has not practiced before the Supreme Court and was not expected to argue any cases in the future. Clinton resigned only from the Supreme Court bar and from no other bar. Every other license to practice law is still in force and is just like the one issued in the so-called de facto state of California. The only possible license to practice law, as a certificate of admissions, is the real license. The California Business and Professions Section 6064 provides additional evidence that bar membership doesn't confer a license to practice law. Otherwise, Cal BNP 6002 would be sufficient in itself with no further requirement that an examination committee must certify that an applicant has fulfilled the requirements for admissions to practice law for being licensed. Regarding the true importance of the examination committee, referenced above in section 6064, the so-called Chief Justice of the Supreme Court can unilaterally overrule its decisions and admit any applicant they see fit, even one who has been rejected as unfit or unqualified. Wow, what a kangaroo court. As the following case sites show, admission to practice law is ultimately controlled by the Chief Justice of the Supreme Court of the jurisdiction. In fact, the Chief Justice is the Supreme Court. Supreme Court has inherited powers and authority to admit an applicant to practice law in this state, despite unfavorable reports upon such applicant by Board of Governors of State Bars. That is based upon Lacey, L-A-C-E-Y, comma, I-N-R-E, parentheses in 1936. 11, CA, capital CA, 2D, 699, comma, 81, P as in Paul, 2, D as in David, 935. The authority of the Committee of Bar Examiners is limited to investigation and recommending for admission those applicants found to be of the prescribed standards. Only the Supreme Court has plenary power to admit applicants who, in their opinion of the court, meet the prescribed test. Whether or not the committee agrees with the conclusion of the court. This is based upon Green versus Zank, Z-A-N-K. This is 1984.2D, District, D-I-S-T, California APP 3D 497, 204, CAL-RPTR 770. The significance of State Bar. The State Bar of California does not issue licenses, cannot issue license because it is a freewheeling private trade union posing as an agency of government. Quoting from a statement issued by Governor Pete Wilson's office in May 30th, 1998, article from the Los Angeles Times. The beleaguered State Bar faces uncertain fate. That is, agencies. It will begin going out of business as a result of Wilson's veto unless legislator acts quickly. Critics 2 years ago launched a referendum on whether to abolish the bar, but with just over half the state lawyers voting, the bar survived. About 65% of the respondents opposed dismantling it. The bar has escaped other brushes with death. In 1985, the legislature refused for several months to allow the Bar Association to collect dues because of its abysmal record in disciplining lawyers. And the existence of the Bar Association hinges on an internal vote of disgruntled Bar Association attorneys complaining about paying dues and disciplining themselves, and could have been abolished in 1985 and also in 1996. How relevant could the State Bar of California actually be? The next section is professional standards. Regarding the conduct and professional standards of esquires, there is no state or federal regulatory agency in their American government such matters. Oceanside, California Republican Assemblyman Bill Morrow, M-O-R-R-O-W, who sponsored the bill for overhauling and shrinking the bar in 1998, is quoted in the same LA Times article cited above. Morrow said that he is not worried that lawyers' discipline will lapse. If no legislation breakthrough is reached by some of the legislature, will simply transfer lawyers' discipline to the State Department of Consumer Affairs, the lawmaker says. Wow. Let's move to another section, playing politics. California Business and Professional 6067 implies that attorneys take oaths of office, and this is printed on the license. But if you read section 6067 carefully, these attorneys are not a member of the state bar, but admitted persons. Section 6067 is designed to lull the reader into a false belief that attorneys take constitutional oath of office. Since the license is effectively the bar card, that is somewhat of a credit card sized piece of plastic, note that the only text appearing on the barcode of the State Bar of California concerns annual union dues. There is no oath here. This certifies that the person whose name appears on this card has paid the annual fee required by statute. That's all it said. There's no oath here. So on further analysis, Code 6067 provides yet another meaningless entry designed to mislead, distract one from getting closer to the truth. Source of the license and title. Since the code painstakingly avoids every actual naming or identifying the imaginary license to practice law, we can safely say that its architects don't really want us to know the underlying source from which attorneys derive their privilege to practice law. Looking deeper, we find there's an underlying aspect of certificate of admission revealed at 7 Corpus Juris Secundum 4 on page 801. In this state, the right to practice law is conferred by letters-patent issued under the Great Seal of the state by its chief executive. The right to practice law is a property right, existing virtue of letters patent from the state as the sovereign. This is based upon 168 A, that is a capital letter A, dot 229 114 N, capital N, dot J, period, EQ.68. The word patent is defined as follows. That is, number one, manifest or apparent to everybody, requiring no search to discover conspicuously evidence, plain as the fraud was patent. Number two, covered or protected by letters patents, secure from interference by government protection. 3, open for general inspection as letters patent. N, 4, that is, law, a grant of any privilege, franchise, etc., made by a sovereign authority. This is a standard dictionary of the English language, Funk and Wagner Company, 1903. Continue. A government protection to an inventor, securing to him for a specific time the exclusive right of manufacturing, exploiting, using, and selling an invention, the right granted. Hint number 2. Hence, any official document securing right, based upon Funk and Wagner Standard Dictionary International Edition in 1958. Investigating the words letter patent, we find history, that is, a document granting some rights or privileges issued under government seal, but open to the public inspection. This is based upon Black's Law 7th edition. Continue on. An instrument proceeding from the government and conveying a right, that is, authority or grant to an individual, based upon Black's Law 1st edition. Next, from within the definition of letter, that is letters patent, an open document under seal of the government, granting some special right, authority, privilege, or property, or conferring some title, is based upon Standard Dictionary of the English Language by Funk and Wagner Company in 1903. If the true relationship between Crown of England and / Britain and the so-called military social construct known as the United States isn't coming into sharp focus for you, I don't know how to make it any clearer. The source of the patent, as well as the letters patent from the beginning, has always been the sovereign, the Crown, the originator of the device, because the Crown has a supreme need for distinguishing in commercial interests in their America, while continuing to conduct business in the name of its strawmen, attorneys, or as they call them, esquires. Conclusion. In conclusion, no attorney can produce a valid state-issued license to practice law, because no such license exists. It is a right granted by the letters patent certificate of admissions. Bar associations function merely as labor unions like the Teamsters, just as a membership in the Teamster Union does not confer the privilege of driving. Membership in the Bar Association likewise doesn't confer the privilege of practicing law. Rather, membership in the Bar Association is a result of being admitted and licensed to practice law. The notion that a Bar Association has any obligation to discipline its members is a fantasy. Whatever occurs is gratuitous. State bar associations cannot be very different than their parent, that is, the American Bar Association, which is a volunteer membership association of attorneys, that is per their website. The reason that esquires can practice law without a state-issued license is that the courtrooms in their America are no longer de jure constitutional instrumentalities. Did you get that? The reasons that esquires can practice law without a state-issued license is that courtrooms in their America, that is, are no longer de jure. They're de facto. They're constitutional instrumentalities of a social compact operating via international public order. They have been hijacked and turned into private, monopolized commercial marketplaces for the enrichment of the owner of code. See essay on the law via private international law. Since there is no, let me just say this. Do you understand how crooked these people are? This is what it's saying here. This is what these people are doing. It's as though they're in the cover of night practicing law. That's what they're doing. And no one, we are claiming that somehow these people are supposed to be responsible, but no one's taking any responsibility in even the state apparatus, that is, of dealing with this. Because it is no longer practicing true law. It's practicing policy. Since there is no requirement that an attorney at law identify himself as an esquire, there must be some other factor to play that induces such extraneous behavior. Admissions to the practice of law as membership in an ancient and honorable profession that has for its goal the furtherance of the administration of justice, and the attorney is an instrument for the achievement of such noble purposes. It's based upon McFarland versus George, APP. 319 SW 2D 662. One who admits to practice as an attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. This is based upon 97 N, capital N, dot W, capital W, dot 2D 287, semicolon 255, MINN, dot 370, IN, re, semicolon, colon, Lord. Okay, I think that takes care of that section. That does. Okay. So we're going to, and it's so funny, the bar is British. Yes, yes, very much so, Christine. We're going to probably stop this one at 30 minutes here because simply as it's, we'll start another section tonight. It's not that late. So let me end the broadcast here, and I'll just start back again, another section, and I'll be right back. Okay? Thank you. Thank you, Christine, for being here. And someone else is here.